This is a lecture from Open Tuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Health and safety within employment law is very important. It's most obviously important in, say, factories and warehouses, where there can be great physical danger from machinery and trucks and forklift trucks and material falling off shelves onto people and so on. But it also has importance in office environments, where there could be cables across the floor, perhaps the height of monitors and keyboards and chairs and so on. I mean that people develop back problems or something because they're always sitting in the same sort of position. We have to be careful that fire exits are properly labelled and staircases are non-slip and so on. If accidents happen, then the consequences for employers can be financially very severe indeed, and obviously for the person injured, it again, of course, can be extremely serious. Now, the duties lie with both employers and employees. So the sort of duties that employers have in health and safety is to ensure that the work practices and the work environment is safe. And I'm not going to go through the whole list which is in the notes, but for example, good ventilation. That if you're in a factory with a lot of dust, the dust is sucked away. That the noise isn't too great, or you give people ear protectors if they're going to be damaged in that way. That nasty chemicals are not released into the atmosphere. The plant and machinery should be maintained to the necessary standard. So we have to make sure all the guardrails are there and so on. That any electrical fittings are routinely tested to make sure no one's going to be electrocuted and so on. We give people instructions, training, and so on how to work machinery properly. There's a health and safety policy there, and people are aware of that. We should be sharing any information we have about hazards. We should be on the lookout for new risks and problems, not just kind of sit back and think, well, we've solved all the health and safety issues now. And we have to, identify people particularly at risk, provide protective clothing, etc., etc. However, there are also employees' duties. Employees are required to take reasonable care of themselves. Employees are required to, if you like, use common sense. Employees are required not to do stupid things like throwing tools across the workplace to their friends and so on. Employees should not interfere with the protective guards on machines. They should operate the machines according to instructions. So I have for example, I have a friend who operates, owns a printing business. And in part of the printing business is they have what's called a guillotine, in other words, a great big blade that comes down to chop and trim paper to the right size. And obviously there's a real danger there that when this blade comes down, that an employee has a hand kind of stuck in a machine and they get injured to the fingers or hand or something as this blade comes down. So there, the way the machines have to work is that to make the blade come down, there are two buttons that have to be pressed, and they're the full width apart. They're about a meter apart, so that you have to use both hands, so that neither hand can be under the blade. And to make it even more difficult, the two buttons have to be pressed at about the same time. So within a few milliseconds or hundreds of a second, so the employee can't kind of go that wouldn't work. It has to be more or less a simultaneous pressing of the buttons. And he says, what do people do? Because it makes their job faster. is that they press one button with their fingers and they put their foot up and press the other button with their foot. And the other hand, of course, could be stuck in there readjusting the paper. So that's an example of employees not doing what they should do. So there are duties on both sides. The employer should have a health and safety policy document. The health and safety policy document sets out the procedures, for example, in terms of fire safety and so on. It will emphasize how important it is to comply with the law, not to be careless, and so on. Can be instructions about the detailed operating of machines and so on. And maybe also saying that only if you've passed a certain exam, got a certain qualification, are you then allowed to do that. So in the UK, for example, we have health and safety surrounding people going up ladders. You have to instruct people in the safe way to work at height. That somebody holding the bottom of a ladder and so on. You should be wearing a helmet and the like. So this has to be set out in writing so that then nobody can claim that they haven't been properly instructed on health and safety. Disciplinary procedures are unfortunately necessary from time to time, not just to do with health and safety, but maybe to do with punctuality, or maybe the standard of your work, or maybe the way you've maybe spoken a bit rudely to a customer or something of that sort. And the way this will normally happen is it may start with a very informal chat, barely getting to the stage of kind of discipline at all, just saying, I thought you maybe were a little bit abrupt with that customer on the phone. Or I think you haven't maybe set this out as tidily as you could do on this report. So it's more of a advice, more of a hint, if you like, at that stage. If that doesn't correct the performance, then you might have to have a bit of a sterner talk with the employee, and there may be a verbal warning, which is kind of saying, if you can't improve the layout and accuracy of this report, then, we may have to take further action. So that's a verbal warning. In an odd way, the verbal warnings can actually be written down and entered into the employee's record, and that's actually quite important to do it, because you need to keep track of where you've got to. If it's informal, but slightly more formal than the informal talk, if you know what I mean, you have sat them down, you've had a kind of formal discussion with them, but you might decide not to actually put that into their record. Although I can't think of any particularly good reason not to do that. And then what you have is a first written warning. This is obviously formal, but you write to a letter saying you have to improve your performance, you have to improve your punctuality, you have to improve your accuracy, or whatever the difficulty is. And that's a first written warning. And you have to give them an opportunity to improve. You might have to give them more training. You certainly have to give them time quite often to improve. You can't normally reasonably expect them to improve quite a lot of skills immediately. Punctuality might be different. You have to look at what the requirement is for the improvement. If still nothing happens, there will be a second written warning. This is what's called a final written warning. This is saying if you do it again, you're liable to be punished in some way. And then if they do it again, the punishments will be suspension, go away for 2 weeks without pay. Or it could be demotion. Sorry, you're not able for this job. We're going to move you back to where you were, where your skills better match it. Or it could be dismissal. Note that there can be some offences which are so grave, they're termed gross misconduct. And this can lead to instant dismissal without any of this lead up through first, second warnings and so on. So if somebody was guilty of doing something really dangerous in the workforce, or somebody was guilty of picking fights with a colleague in the workforce and hitting them and so on, then that would be gross misconduct, and they could be immediately dismissed. What we should be doing in disciplinary procedures is we need to establish the facts. So how often has this person been late, for example? By how much are they late? We need to know what we're talking about. We have to inform the employee that there's going to be some sort of formal meeting now. And then we hold a disciplinary meeting, and the employee will normally be entitled to bring a representative with them. It could be a trade union representative, or it could just be a colleague to speak up for them, to give them a bit of moral support. You hear what they have to say. You can discuss the different points of view to see if there's any mitigating circumstances there. Then you decide on the action. And the action, as I say, could be suspension. It could be send them away in a training course. It could be dismissal if it's up towards the end of the cycle of disciplinary procedures and so on. And then there should be a process of appeal. So people should be able to say, well, I don't think that demotion was fair, or that suspension is too long for what I did, and so on. You must leave room for appeal. Termination of employment. Employment can be terminated in 3 ways. Retirement. The person resigns, maybe because they're moving job. Or the contentious one is dismissal. And there are 3 forms of dismissal. You can terminate someone's employment. Basically, you can sack them. Okay? It can be the ending of a fixed term contract, so without renewal. So somebody's been employed for 2 years. If it gets to the end of the 2 years and you don't offer to renew their contract, they have been dismissed. In many ways, there's almost nothing really like a part-term, a limited time contract. Because once someone is dismissed, then they can bring action for unfair dismissal. And then we have constructive dismissal, which I mentioned earlier. This is where the employer acts in such an outrageous way that the employee is entitled to believe that they have been dismissed. So some sort of radical demotion without there being any disciplinary needs for it, or some sort of radical change in their duties. You can say, well, I've really been sacked from that job. That's not, the job I'm doing now is entirely different. And I regard myself as having been dismissed. The remedies for dismissal are as follows. You can have reinstatement, and reinstatement is where you get your old job back. But of course, by the time this all goes through employment tribunals and so on, your old job's probably been taken by somebody else. There can be re-engagement. Re-engagement is where you're given a job of the same sort of status and pay. But you realize, of course, by the time there's been employment tribunals and arguments and so on, that the kind of relations have broken down between the employer and the employee. The employer probably doesn't want the employee back. The employee probably doesn't want to go back. And by far the commonest form of remedy is compensation. What makes for fair dismissal? Now we know that the sorts of dismissal here is termination, sacking somebody. That's really what we're talking about here. What makes for fair dismissal? And here's what we have. It is fair if it's caused by redundancy. So the employer, the business is having to contract a little bit. They've lost major contracts, or the market is shrinking. They're closing down a factory. Then the people employed at that factory can be dismissed. And fairly. And what you have to make sure is that the selection of people to be made redundant is fair. Non-capability. You employ someone, you expect them to work this piece of computer equipment, but despite training, despite giving them time, they still can't do it. Or a delivery driver loses their driving license, they can be dismissed because they're no longer capable of doing it. And that also comes under legal restrictions. So sometimes if somebody doesn't have the right qualification or can't pass the right exam, perhaps in financial services where you have to pass exams every so often to make sure you're up to date with legislation, then they can be dismissed. Misconduct, lateness, being rude to people, not complying with health and safety regulations. Once you go through the kind of verbal warning, the first written warning, the final written warning, this makes for fair dismissal under misconduct. Other substantial reasons. And one of the examples given for other substantial reasons, you have, let's say, the sales director of your company is married to the sales director of another company. It can be assumed that these people will chat at home, and you can dismiss your sales director because there is this danger of commercial secrets being transferred. Even if it's inadvertent, even if they don't mean to do it, it is kind of assumed. Married couples chat about work usually, and there's a big risk that something could be leaked to a competitor. Dismissal is automatically unfair if it's because the employee becomes pregnant, or they join a trade union, or they're carrying out health and safety operations. You can't dismiss somebody for asking for a machine to be stopped to repair it and so on, or if they insist on an employment contract or proper pay slips and so on. Finally in this, and fairly quickly, we'll just look at data protection. This applies both to employees and to suppliers and to customers. And we all know that businesses like supermarkets and Google and the mobile phone companies collect huge amounts of data. We should be concerned, and the law is concerned, that the data should be correct and up to date. Incorrect data is going to give incorrect decisions about people. Incorrect data about whether or not you have defaulted on a loan could mean you're never going to get a mortgage. Is it held safely? And we've seen very large companies like Yahoo and like Amazon, where their systems have been hacked into, and data has been released, sometimes with credit card information, which may cause harm to their customers. What damage would be caused if the system was hacked and other people could access it, or just the data was destroyed, erased in some way. Think what would happen if a hacker got into your medical records and just erased them, so that the doctors and hospitals didn't know you were allergic to certain drugs. And is the data relevant to the decisions being made? Or is data just being gathered for the sake of it almost, so that the amount of data is way above what's actually required for the processes that are going to be carried on by it? Data protection legislation, certainly in Europe it was brought in by a directive. In the United Kingdom there's a Data Protection Act, and all of these EU-type laws look at the following. So the data has to be processed fairly and lawfully. It has to be acquired fairly and lawfully. It has to be obtained only for certain specified purposes. And in the UK, companies have to register why they have the data and what they have the data for, and so on. It mustn't be excessive to what's required. It must be for that particular job. It must be accurate and up to date. It mustn't be held for any longer than is necessary, because again, this is exposing people to danger. You must give people the right to see the data and to correct it. You should process it properly according to the rights of the data subject. You and I are data subjects. There must be appropriate measures against unauthorized and unlawful processing, people using the data for wrong purposes or giving the data to somebody else. And finally, in EU legislation, you're not allowed to hold this data outside the EU where the data protection legislation may be weaker, and by moving the data, kind of offshoring the data, then it is exposed to hacking or misuse and the like.